882 in the matter of Luann K. Is it Trummel? Ms. Trummel? Trummel, original action and attorney discipline.
Good morning, and may it please the court.
Rise.
Good
The
morning.
Honorable Justices of the Supreme Court. This court from recess now sitting.
Thank you. Hey, good morning. Please be seated. Mr. Shima, would you please call the 10:30 docket?
The first case on the 10:30 a.m. docket for Tuesday, December 16th, 2025 is appeal number 128178, State of Kansas versus Rico Jermaine Brown Jr., appeal from Sedgwick County.
Good morning, Emily Brandt, Appellate Defender Office, representing Rico Brown, present and ready for argument.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Second case is appeal number 128882 in the matter of Luann K. Trummel, original action and attorney discipline.
Good morning, and may it please the court, Kate Duncan Butler for the Office of the Disciplinary Administrator, present and ready for argument.
May it please the court, Luann Trummel appearing pro se, present and ready for argument.
Thank you.
Your Honor, that concludes our 10:30 docket.
Thank you, Mr. Shima. I will now call the case of State of Kansas versus Rico Jermaine Brown, case number 128178. Counsel, you may approach. Morning, Ms. Bryant. You may proceed.
Good morning, may it please the court, Emily Brandt, Appellate Defender Office, representing Rico Brown. May I please request 3 minutes for rebuttal?
3 minutes will be granted. Thank you, Ms. Bryant.
Rico was deprived of a fair trial, and this court must vacate his convictions and remand for a new one. Rico understands that he is not entitled to a perfect trial, but he is constitutionally entitled to a fair trial. Rico stands convicted of the most serious offenses in the Kansas Criminal Code based on circumstantial evidence and inconsistent statements of other suspects in the murder of a juvenile, Ethan. Rico submits that his trial for these serious offenses, marred with distractions and error, could not have been a fair trial. The cumulative nature of the issues raised on appeal are too great to survive reversal. I intend to touch on all of the issues raised in the brief because I do think that in Rico's case, the cumulative error of those issues demands reversal in this matter. But I will start with the mistrial. First, a fight. I think the record is a little unclear whether this fight actually broke out in the courtroom or in the hallway of the courtroom, and whether or not jurors in the courtroom could see out into the hallway to witness the fight. Certainly, though, we know the jurors witnessed 10 deputies running through the courtroom while they're sitting, and that a verbal altercation could be heard by the jurors. During this verbal altercation, one attendee of the trial called another attendee of the trial a bitch, and references to a gang, the Crips, were mentioned. In response to this, I think rightly, the district court dismissed the jury. After the fight had been de-escalated, the jury was brought back into the courtroom. Again, I think the Sedgwick County Courthouse probably has an untold number of jury trials going on at any time, but the jurors are told that the fight is probably related to Rico's trial and that they're going to be escorted to their cars for safety. And that concludes the first day of jury trial and presenting evidence. When they come back the next day, the district court confers with the party. The district court suggests, I'm going to admonish the jury, let them know, because they'd found out the fight wasn't in relation to either Rico's family or the victim's family. I'm going to let them know that, and that, they won't assign any weight to that to either party. But then when the jury came back in, the admonishment from the district court was not that the jury couldn't consider that fight during their deliberations. It wasn't that they couldn't hold that against Rico. It wasn't that they shouldn't fear for their safety, because again, they still knew that that fight was in relation to the jury trial they were sitting in. They knew it wasn't maybe about Rico's family or the victim's family, but they knew it was about someone. And if you look at that in the context of other things that happened in this jury trial, I think particularly in the background of the state discussing Rico shooting someone dead in street justice with his associates, and you've now had a fight break out where there are gang references, and you've been told that that fight is in relation to the jury you're sitting on, and you've had to be escorted to your car for your safety, you probably do fear for your safety the rest of this jury trial. You have been told that the defendant shot someone in retribution for something he didn't like. Do you think a jury sitting on that panel doesn't think that he or his associates wouldn't shoot them for a verdict he didn't like? And so I think that that really set the tone for what this jury trial looked like, because street justice and associates are mentioned during opening statements. And then on the first day of jury trial, we have this fight break out in relation to this jury trial. I think we then move to the potentiality of witness coaching. Again, we don't have a strong first-degree murder case here. We have circumstantial evidence that Rico was texting Doug. We don't have Doug, though. Doug pleads the fifth and does not testify at the jury trial. We read his preliminary statements, which suggest, one, Rico is the shooter, and two, Rico had nothing to do with the shooting at all. And so the only eyewitness, allegedly, to this murder is Cam. So Cam is critical to the state's case in chief. Cam needs medication support. He has cognitive impairments, and his mother is sitting in the trial and is mouthing things to Cam or making signals at Cam. Talk more, stop, trying to get the attention of Cam's attorney, also to say, I think Cam needs a medicine break. And so I think that this, when you look at this again in the context of this jury trial, people noticed that this was happening. And the district court found that probably the jury didn't see it, but I don't know how we can say that when one of the jurors literally brought to the district court's attention that the actions of attendees of the jury trial were so distracting that they wanted the district court judge to do something about it. And so it's not that the juror's attention was fully on Cam while he's testifying, so they're not noticing his mom in the audience trying to signal to him or coach him or get his attorney's attention. In fact, we know that the jurors are looking at the attendees. It's distracting to them that they keep getting up or making commotions or leaving the courtroom or their cell phones are going off. And so again, I think with this backdrop of what is going on, we have to consider that these errors are just sort of like piling up. And then we have miscellaneous mishaps and distractions, right? We have emotional responses to body camera footage. We have cell phones going off, people repeatedly coming and going during the trial, such that the district court has to make a rule that if you exit the courtroom, you cannot come back in until the next break. Enrico notes, as does the state, it's possible individually, right? These distractions and the court's responses are not reversible and that the court's responses were appropriate. But I think that that's the benefit of appellate review, right? Appellate courts can take a broader view than the district court to determine whether a trial could continue without some sort of injustice to the defendant. Because again, the district court and the parties are all trying to get through a jury trial. And so when one thing pops up, they address it, they try to give it some sort of curative instruction or admonishment to the jury. They're trying to press through a jury trial and protect everybody's rights. And so I think when you are in the forest, it can be difficult to see that those individual problems or those instructions are not good enough when you are looking at it from a bird's eye view. These things just sort of start to add up. So even if they are reasonable in the moment, when you take a step back and you are convicted again of the most severe offenses in the state of Kansas, these sort of things mar your right to a fair trial, particularly when they're compounded by prosecutorial errors that permeated opening statements and evidence and closing. And again, we don't just have prosecutorial error possibly in opening and closing. We have disparaging remarks about Rico's counsel during evidence. We have the state saying, when there was an objection to foundation, the state goes, well, that's all the foundation the defense was really put on. So do I have to do more? This idea that your actions should comport with the actions of co-counsel are not things that counsel should be commenting on, which the district court admonished the state. And then during rebuttal closing, we have the state saying, this isn't the state versus Doug. That trial may come. I may see if defense counsel is available, she should be prosecuting that case. Those are not the kinds of comments that fall within the wide latitude of a prosecutor's discretion. I agree that it was Rico's theory that Doug is the shooter, that Doug is culpable in this murder of Ethan. And so I think it's probably fine if the state then says in rebuttal, this is not the state of Kansas versus Doug. That trial may come. But then to go on to suggest that the defense attorney should be prosecuting that case when the defense attorney is there to protect her client's interests and to provide Rico Brown with a constitutional defense, I just don't think that's okay, particularly, again, in the background of what we have going on. And we have this weak case where the prosecution is also burden shifting. The prosecution, in questioning Detective Davis, they're talking about his interview with Doug, because again, Doug doesn't testify, but Doug does give a nearly 9-hour interview with the police. And the state, looks at Detective Davis and just says, well, shoot, can't the defense admit that entire 9 hours of interview? But Rico has not suggested at any point that the state is hiding the ball about what's going on. The state's going to direct examination on the points relevant to them. Rico will cross-examine on the points relevant to Rico. Nobody has to enter the video into evidence, but the state has now suggested, without anything from Rico, that if Rico doesn't submit that tape into evidence, that he is hiding something, despite the fact that he has no burden to present any sort of evidence. And there are things in the tape unfavorable to Rico, right? Because Doug does implicate him in the shooting. And the entire tape does end up getting admitted to go back to the jury. And then they further dilute their burden in closing by suggesting that, like, this weak case where we don't, again, one eyewitness doesn't testify at trial and has recanted that Rico was the shooter. The other eyewitness is wobbly on the stand at best about who the shooter is. Nobody can even say where Rico Brown was in the car at the time of the drive-by shooting. The state then to suggest that the jury cannot hold the Sedgwick County Police Department's lackluster investigation against the state, that's simply not true. You are poking holes in a state's theory of a case. That includes reasonable doubt that the police didn't actually investigate this crime. They focused on one person and they went for one person, and that is who they brought to trial before you. It's not good enough that you can go complain to the police chief that you don't think Detective Davis did enough in this case. If they thought Detective Davis didn't do enough in this case, they needed to return a not guilty verdict for Rico Brown, not complain to the police. And I think particularly in light of the fight that broke out, the prosecutor committed prosecutorial error by mentioning that Rico had enacted street justice by shooting Ethan, and that Doug and Cam were his associates in this murder. There was an order to not introduce or reference any gang-related evidence. This inflamed the passions of the jury, particularly a jury that is possibly afraid for their life, who think Rico Brown might enact street justice against them if they return a verdict against him. And I know the state has suggested, well, there's just a fair comment on the evidence, right? Instead of calling the police about a robbery, they went and shot Ethan. I just don't think that's fair on the backdrop that this is a weak case against a young Black man, right? Many of you are associate justices of the Supreme Court. In this context, it might be fair to call you associates, and that wouldn't have any sort of racial connotation to it because that's what you are. But when you start talking about associates and street justice, when you've been ordered to not talk about gang affiliations, you're implying to the jury that the defendant is related to a gang. I just think the cumulative nature of all of these errors has deprived Rico of a fair trial. As the state notes, some of this could be expected in a 7-day jury trial, but all of this, I think this court has read enough first-degree murder records to know that every day across the state of Kansas, first-degree murder jury trials occur without this multitude of distractions, fighting, multiple cell phones going off, witness coaching and interference, people coming and going so frequently that a juror is distracted by it, prosecutorial error that shifts the burden, comments on defense strategy, interferes with a witness's testimony, and associates Rico Brown with a gang. I think all of this, with credible evidence that a juror knew Ethan's family and returned a verdict for them, means that this case was so marred by error that it must be reversed on cumulative error. I'll stand for any questions of this court.
Any questions?
I have a question. On the motion for mistrial, could you speak to what our review looks like in addressing how does abuse of discretion fold into what might otherwise seem like an unlimited harmlessness analysis?
So I think that abuse of discretion folds into it's abuse of discretion for whether or not a fundamental failure occurred, and that burden is on Rico Brown. And so I think that we've put forward that there were fundamental failures, particularly in the fight and the witness coaching and the cumulativeness of the miscellaneous mishaps and distractions, particularly because the court was giving curative instructions and or making rules in the courtroom to try to mitigate those things. Then the burden shifts to the state to prove beyond a reasonable doubt that it was possible to continue the trial without prejudice. And so again, I think if you look at them individually, maybe at each turn it was possible to keep that jury trial going. But cumulatively, I don't think the state can prove that this trial could continue without any prejudice to Rico Brown. And so I think that's where the burden shifts to the state to prove constitutional harmless error.
When you say cumulative, I at least am getting a little confused as to the cumulative nature of the arguments for a mistrial and then on appeal, the cumulative error standard. Are you bouncing back and forth between those two or not?
Well, because I think that it is twofold, right? It's like the prosecutorial error too, right? We've raised multiple prosecutorial errors. So this court could find one prosecutorial error reversible. They could find that the cumulative nature of the prosecutorial errors is reversible. I think the same is true for the mistrial.
Okay, so
I think it's cumulative within cumulative. So
well, that's what I'm wanting to get at. So one of the argued reasons for a mistrial is the fight.
yes,
The fight is not an error.
right.
The error alleged is that the court abused its discretion by not ordering a mistrial.
Right.
So if we were to disagree with you on that and find that the district court did not err in refusing to grant the mistrial, are you arguing that the fight still gets put into the cumulative error bucket later on? That's what I wanted to figure out.
I think yes, you're
But
right.
it's not an error, I guess is what that's what I wanted you to address. How
Yes.
can we put again, in the scenario I've described, which I understand assumes certain things. But in that scenario, how do we get the factors that led to the motion for a mistrial into the cumulative error bucket alongside the prosecutorial errors and so on?
I think it's because I think it's McCullough, and I know it doesn't go to necessarily cumulative error bucket, but I think that McCullough does stand for this proposition that appellate courts get to take a wider view than district courts when it comes to considering whether or not a trial could continue without injustice, because again, you all have the benefit of the full record.
That's all in the mistrial.
Yes. And so, but I think that if you find that the cumulative nature of the mistrial bucket is error, and if
we
you found that
would just stop and say you should have gotten a mistrial, right?
right,
Nothing
and
else needs
so
to happen.
yeah, so I think if you found that none of the subsections of the mistrial were error, right, it wouldn't go into the cumulative bucket. But I think if this court has concerns about, because again, I agree with the state and the defense counsel below agreed, I don't think the district court necessarily erred in its actions at the time that the fight occurred. I think that it erred in denying the motion for mistrial because the district court should have been cumulatively looking at how all the mishaps, quote unquote, affected Rico Brown's case.
At what point did the motion for mistrial was made? What point was it made?
I believe it was made at the close of state's evidence. And I can correct that record if I need to, and my co-counsel might, or the state might correct that as well, but I believe it was kind of used as like a motion for judgment. Because again, I think at the time everything happened, everybody's trying to get through the trial. And so at the time that the curative instruction or admonishments are giving, everybody does want the trial to keep going. And then if you look with hindsight, you realize that maybe these have built to such an extent that the jury couldn't have given Rico Brown a fair trial because of all the distractions.
Any other questions, colleagues? Ms. Brandt, thank you.
Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'm going to start with issue 1, and I want to start by emphasizing something that was brought up in the questioning, which is the standard of review. This is reviewed for an abuse of discretion, and I cited on page 6 of the brief at the start of that first issue, the case law from this court indicating that the first question is, did the district court abuse its discretion when deciding if there was a fundamental failure? And then secondly, did the district court abuse its discretion when deciding whether the conduct caused prejudice that could be cured or mitigated through et cetera, et cetera? And I think that's important because turning to that first instance that counsel is arguing justified a mistrial. And I want to start, and at the risk of being accused of just emphasizing semantics, but I think it's important here. I heard the word fight dozens of times in counsel's argument. There was not a fight. There was a verbal argument. There was never any allegation below that there was a physical confrontation. And in fact, I think the record clearly shows otherwise, that there was arguing that occurred. The record does also appear clear to me that this occurred not in the courtroom, but in the hallway. In fact, the district court mentioned at least once that the blinds were closed with maybe one exception. One was partially open. And that's why the court didn't even know or didn't even think that the jurors were likely to have seen this. So when you look at what the court said about this, I think it does become quite clear that this did not happen in the courtroom. It's also important to note that this happened during a bench conference. It didn't happen while any evidence or testimony was being presented. So there's no concern that it distracted the jury from hearing testimony or evidence as it was coming in. It's also important to note that the jurors were told that it did not involve either party, either the defendant's family or the victim's family. So again, we have a verbal dispute that occurs in the hallway that the jurors likely did not see. It's questionable to what extent they heard what was said. And they were then told, look, this doesn't have anything to do with the defendant's family. It doesn't have anything to do with the victim's family. So I just want to emphasize this is a far cry from a situation where we have a brawl in the courtroom. And I think it's safe to say
It happened that jurors get escorted by the sheriff's office or by officers out to their car at the end of a day of trial.
right. And I think that's a reasonable move on the district judge's part, just to allay any possible concerns at that point that the jurors might have had. And I'm not suggesting that.
So it gets them to their car. I'm not sure it doesn't linger as far as why would it happen? What's the problem that I would need to be escorted that day? And do I have a safety problem the next day or the day after? Yeah, I mean, that's a pretty unusual thing to happen.
It might be, it's unusual, but it's far from, I would guess that every one of us in this courtroom has seen news reports or seen videos of actual physical confrontations happening in a courtroom. And I don't think that automatically leads to a mistrial even when that happens. So when you're talking about something that happens outside the courtroom, and to the extent that there could have been safety concerns, that's a different question than whether they would have had safety concerns that would be focused on the defendant. Counsel's arguing today that, well, they might have been concerned that if they returned a not guilty verdict, that the defendant and his family then might have acted out of revenge, just like this shooting happened out of revenge. But I think that that's alleviated by the fact that they were already told that it didn't have anything to do with either family. So to the extent that there might have been some lingering fear, first of all, I don't think the jurors never indicated that to the judge. And so I think that mitigates that argument to a large degree. But again, I think regardless that we have the fact that they already know that it didn't have anything to do with the defendant or his family.
Was there anything put on the record as to the motivation of the district court judge to have the jurors escorted?
I think
You see a multitude of, just to play it safe, or I do have a concern that they might fear, so I'm gonna leave it. Anything put on the record that?
I think more the former. I think he just basically was doing it out of abundance of caution that
I
he.
think that, was it articulated?
I believe so, and obviously the record will speak
All
for
right.
itself. I do think that he did indicate that at least on the day of, and then maybe again the next morning when they addressed it again. But I do think that on the day of, both when he was just speaking with the attorneys and then after the jurors were brought back in the room, I think he said a couple of times that he had no reason to actually fear for their safety, but that he was just going to do it essentially as out of abundance of caution to have these deputies escort them. Next was the argument with respect, and I know counsel just briefly touched on it here today, but the argument with respect to the witness, Solomon's mother. Couple things that are important here. First, we had the state's investigator and the defense investigator both essentially testify outside the jury's presence, and they gave conflicting testimony. The state's investigator essentially said, look, this was all about her concern for Solomon's physical well-being because he hadn't taken his medication, and that she was simply trying to get his or get somebody's attention to make sure that he did that. Then we had the defense investigator who was more suggesting that she was making gestures with her hands. But I think a couple things that are important here. Even the defense allegation was not that she was trying to coach the content of the testimony. At most, she was trying to get him maybe to wrap things up, but she wasn't trying to tell him what to say in the testimony, even according to the defense version of what happened here. But then I think equally important is the fact that the district court, who obviously, unlike all of us, was in the courtroom, he made an express finding that there was no indication that either the jurors or Solomon ever saw anything that Solomon's mom was doing. So while counsel has speculated today that they could have, because the jurors had brought up other issues such as people coming and going at some point in the trial, I would argue that the fact that they did bring that other matter to the court's attention, but never said anything about this, would seem to suggest that they did not. But more to the point, I think we have to respect the district court's factual finding that there was no indication that they actually saw anything that happened here. So to the extent we had a person in the back of the courtroom making gestures that no relevant participant saw, I think that's largely a non-issue. The other issues that counsel pointed to in the brief, spectators coming and going and cell phones a couple times ringing. The right to a public trial is a constitutional right afforded to the defendant. And it's one of the rights that I think makes our judicial system the best in the world. But it does come with certain distractions that are inherent in that. And I don't try cases, but I've certainly sat in on my share of trials or portions of trials over the years at the district attorney's office. And if I'm in the courtroom for even an hour, I can't recall a single time where there hasn't been at least somebody entering or exiting. And you might hear the door, people might glance over to see what's happening or who it is, but that's simply inherent in any trial, especially one that lasts 3 days here. Same with cell phones going off. Obviously, that's a more recent trend, but it is something that I think I've certainly read my share of transcripts in cases that I've worked on where the court has had to issue a reminder to whether it's the gallery or even sometimes the attorneys to turn off or silence their phones. So these types of things do happen on a fairly regular basis in trials. And I think that when you see this in writing in the span of a few pages in a brief, it can sometimes seem like, oh my gosh, there are so many things happening here. They're just listed one right after the other. But when you're talking about a 3-day trial, where I would guess that probably means you're talking about 20 hours worth of actual substantive evidence and testimony, and we have 2 instances where the court mentioned cell phones going off, and then we have people entering and exiting. And to the extent that the court in this case decided to place some restrictions on when people could enter and exit, I think that's just a case of a judge who is being even more cautious and protective of the participants than a normal judge would be. Because frankly, I think far more often than not, in my experience, when people enter and exit, the court doesn't even bother mentioning it because it is just something that is so common in a system where public trials are guaranteed. I think the other main issue that counsel talked about today was the prosecutorial error comments. I want to start with, I guess, the gang issue. This was a case where both parties acknowledged that this shooting was committed in retaliation for the earlier robbery of Patterson. The only question essentially was whether the defendant was a participant. The defendant was arguing that this was Patterson's case, that the defendant was more or less literally along for the ride. So nobody disputed the fact that this was a case where the shooting was done in retaliation, in revenge for an earlier action. And I think I cited in my brief, Williams was another case where the phrase street justice had been used. And this court said, look, it was an accurate reflection of the evidence. It helped explain the motive. It helped explain and put the testimony in context. And that's exactly what we have here. The words street justice themselves do not automatically imply gang. Clearly, there are people who act out of revenge who have no gang ties whatsoever. And so using that word or those words, I don't see as problematic where it is an accurate summation of the evidence. The word associate, I would note that when the prosecutor used that in opening statement, he used it in conjunction with the word friends. He said friends or associates. And while we as attorneys who practice criminal law and this court who tries or who handles ample criminal law cases in your work, while we might associate the word associate with gang, we might know that that's something that is a term that is connected to gang members. I don't know that a common juror would necessarily realize that associate is the lingo that is connected and what is gang members are referred to sometimes. But especially when it's used directly after the word friends. And we all know also that just in common language, taking it out of the court context and just in society in general, people do refer to friends, co-workers, other people as associates. And so counsel, I think, is really reading into that word when it is a benign word that unless you have an expert level knowledge of gang membership, a common juror simply is not going to interpret the word in that manner. Burden shifting was the other argument that counsel made today. And again, I simply disagree that that's what happened here. The defense had very strongly suggested that Patterson's statement should not be taken at face value or credibly, in large part due to the length of time that he spent in the interview room and the nature of the interrogation. And so for the prosecutor to simply point out that the defense was free to admit any and all of that interview is the exact type of thing that this court has repeatedly said is appropriate in response to an argument that somehow the state's evidence is lacking or that there's a reason to question the state's case because of something that the state has not admitted. And so here, when you have a defendant who is repeatedly emphasizing, well, Patterson was in the room for 8 or 9 hours, wasn't he? And didn't he give all these different versions and he changed his story multiple times? The prosecutor simply did what is allowed when he pointed out that, hey, the defense is free to admit the entirety of that interview. And so that's what happened there. I think that I've covered all of the main, I do want to say, I guess the other comments was that the other argument had to do with essentially the prosecutor disparaging defense counsel. And here again, I think it's important that the trial judge, who of course witnessed everything, did make a specific statement that he did not agree with the defense's position that the prosecutor had repeatedly disparaged counsel. I think the court essentially said, look, there was one comment that the court felt was maybe a little bit inappropriate, but he didn't think that there were repeated instances of it. And I would argue that that's accurate in this case. I think the one comment with respect to the first thing that counsel argued about when the prosecutor said, look, I see I'm out of time, if I could. Thank you, Your Honor. The prosecutor essentially said, look, I thought I had laid the same foundation that defense counsel had. I don't think that's an inappropriate response when counsel objects to a question. The defense had used the exact same approach in questioning Detective Davis, and they had all used this analogy of a funnel when addressing these phone records. And I think the prosecutor was simply trying to articulate that, hey, I thought that I had appropriately laid the foundation, just like counsel on the opposing side had. So that little aside, I don't think is really disparaging defense counsel as much as it's just the prosecutor trying to explain the tactic that he used. The other comment about it being Patterson's case and seeing if defense counsel would be available to prosecute that case, I think even the prosecutor would acknowledge that he could have made that point without making that latter statement. But I think when you look at the comment in its entirety, what he's saying is, look, your job as the jurors in this case, State v. Rico Brown, is to determine Rico Brown's guilt or innocence. It's not to worry about whether Patterson was guilty. And he did acknowledge Patterson was involved with this case, and he likely will be tried or he will face criminal charges in this case, but that was not this jury's concern. So while again, I would acknowledge that it would have been a point better made without referencing defense counsel's availability, I think the broader perspective is we're here to try Rico Brown's case. Don't get distracted from whether somebody else was also criminally responsible for that. And he acknowledged that, yes, more than one person can be charged in a case. We're not suggesting that DeQuaylen Patterson was blameless in this. But again, redirecting the jurors to the fact that you're here sitting in the case of State versus Rico Brown. I have exceeded my time, and I would submit the remaining issues on the brief. But our position again is that simply the defendant has failed to meet his burden of showing that these issues that have popped up during trial, either individually or cumulatively, necessitated a mistrial. And I do think it is very significant that defense counsel specifically told the court that he thought that the trial court had handled every issue really well. And I do appreciate counsel's argument that at some point things can accumulate to the point that you would have to declare a mistrial. But I don't think we got there in this case. And I do think it's significant. This mistrial request was made at the close of evidence. So at the time the district court ruled on it, it did have the totality of the picture. This isn't a situation where they moved for a mistrial early in trial and then 3 or 4 more things happened. And now we can look back and judge it more in its entirety. The district court had all of the information and it handled all of these issues, and I think he handled them appropriately.
Any other questions, colleagues? Thank you, Mr. Malone.
Thank you, Your Honor.
Ms. Brandt, you reserve 3 minutes.
May it please the court. I just want to touch briefly on maybe 1 or 2 things. If the shooting was done in retaliation, how hard is that to say? Tell the jury that the shooting was done in retaliation. I think that it is a dog whistle to then say that it was done for street justice. You are trying to link Rico Brown to a gang. And maybe friends and associates out of context, you don't know that associates might be a gang term. You've linked it to a street justice, though. It's not outside of context. The state has told the jury that Rico Brown was seeking street justice against Ethan, and he and his associates went in a drive-by shooting and shot him. I think that those are dog whistles for the fact that Rico Brown is involved in gang activity. And I think if the state had just wanted to say that it was a retaliatory drive-by shooting, the state would have said that. I think the state specifically chose these words to link Rico Brown to gang violence when they were directly told to not introduce any gang evidence. And we have Kansas case law that says use of the term associate can be linked to gang evidence and is inappropriate. We have Winston from 2006 and Peppers from 2008. And I would encourage this court, if you have not done so already, there's an article cited on page 38 of the brief. And that article finds that improper allegations of gang involvement can transform a weak case into a dead bang winner for the prosecution. And I think that's what we have here. I think we have a weak case against Rico Brown. Doug recanted that Rico Brown was involved in the shooting. Doug and Kim are best friends. He wasn't going to roll on Cam. Cam can't say that he saw Rico Brown shoot the gun. Cam can't say whether Rico Brown was driving or whether Rico Brown was in the back seat of the car when he shot the gun. This is a very weak case for first-degree murder. And on top of everything, I just don't think that this court can cumulatively say that Rico Brown got a fair trial. The state should do this again. They should be required to try Rico Brown again for first-degree murder if they want to sustain that conviction. I'll stand for any questions.
Questions? Thank you, Ms. Brown.
Thank you.
I will now call the next case on the docket in the matter of Luann K. Trummel, number 128882. Counsel, you may approach. Morning, Ms. Butler.
Good morning, and may it please the court. Kate Duncan Butler appears on behalf of the Disciplinary Administrator's Office. Justice Rosen, I would respectfully request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. This case is an original proceeding in attorney discipline involving the respondent, Luann K. Trummel, who has been licensed to practice law in the state of Kansas since 1993. This case comes before the court after an evidentiary hearing held on November 20th of 2024. Prior to the hearing, my office filed a formal complaint alleging violations of KRPC 1.1 competence, 1.3 diligence, 1.4 communication, 1.15 safekeeping client property, 8.1 subsection B duty to assist, and also Supreme Court Rule 210 duty to assist. Ms. Trummel admitted to violating these rules in an amended answer that she filed on November 18th, 2024, as well as at the formal hearing. She also admitted to the operative facts contained in the formal complaint in her initial answer, which was filed in October 2024, at the pre-hearing conference, in her amended answer, and again at the formal hearing. In short, although there's not a formal stipulation of facts present in this case, most of the facts in the formal complaint were deemed admitted by Ms. Trummel and served to support the violations, although there was additional nuance provided on the record at the hearing. In its final hearing report filed on February 28th, 2025, the hearing panel found that Ms. Trummel violated all of the alleged rules except for the KRPC 1.1 violation that had actually been withdrawn at the beginning of the hearing. The hearing panel recommended that the discipline be a published censure. No exceptions have been filed in this case, meaning the only issue before this court is the appropriate discipline. At the time of the hearing, my office recommended that the hearing panel impose an informal admonition to Ms. Trummel. However, today, our office is asking that this court adopt the recommendation of published censure. There's 2 reasons for that. The first is that to impose an informal admonition, this court would have to remand the case back to my office. And as very recently, this court pointed out in Ray Wagle, that is reserved for extraordinary circumstances, which do not appear to be present in this case. Second, the decision of the hearing panel and its reasoning for the recommendation is very fully laid out in the in its final hearing report, and really comes down to how the hearing panel credited and weighed the evidence. They didn't find additional or different violations. They just weighed the evidence differently than our office had when making the initial recommendation. And we do not object to or challenge that calculus at this time. So to briefly summarize the facts of this case for the court, client KH hired Ms. Trummel to represent him in a child custody matter. He lived out of state, but the other parent lived near Ms. Trummel. Because he lived out of state, they communicated primarily over the phone and via email. KH paid Ms. Trummel an initial $600 retainer. He understood that he would be paying more over the course of the representation, but the contract they entered into said that $600 represented the first 4 hours of Ms. Trummel's work. It is undisputed that Ms. Trummel deposited that money directly into her operating account rather than into her attorney trust account. It is also undisputed that she has no records. There is no evidence of whether or when she earned any of that money. At the hearing, she testified about some of the steps she took in KH's case, but she could not recall, and nor is there any documentation to show whether that happened before she deposited the money or after, meaning that it was unearned at the time that she deposited it into her operating account. Now, Ms. Trummel knew that she would have to serve the other parent for this child custody case, so she decided to investigate the address she had for the other parent. She drove past the house and concluded from that action that it was unoccupied. From that point, she recalls telling KH that the address was wrong. However, KH does not recall having that conversation. And apart from a document that was reviewed at the hearing but is not in the record, it is not clear whether that call took place. Nevertheless, what is undisputed is that Ms. Trummel and KH no longer communicated after that time. Ms. Trummel admits that KH reached out to her and she did not respond. I believe her testimony at the hearing was other things kept getting in the way. And the attorney-client relationship was never formally terminated. So in December 2022, KH filed a complaint with our office. Ms. Trummel responded to the initial complaint in January of 23 and explained that she didn't think she had a good address, but then she proceeded to not cooperate in any more of the investigation. She did not communicate with the volunteer investigator, nor with the in-house investigator from my office who reached out to her. The first communication my office had with her after the January 2023 response was when she came to the pre-hearing conference in October of 2024. Now, Ms. Trummel at the hearing explained why she did not cooperate. She said she knew she had made mistakes, and I believe her exact word was that she had flailed. She basically didn't know how to make the situation better. And she talked about having anxiety and the role that played in this. However, after the pre-hearing conference, she re-engaged with the disciplinary process. She filed an answer. She sat for an interview with our investigator. She took responsibility for her misconduct, and she refunded KH like the week before the hearing or roughly around there. So as I said previously, my office filed a formal complaint that was filed in September of 2024. Ms. Trummel answered first on October 18th and filed a subsequent answer on November 18th. In those, she admitted to the facts and then later the rule violations. And we withdrew our KRPC 1.1 allegation at the hearing because we determined that the misconduct better fit under the other rules. So I talked a little bit about the recommendation already that we had recommended in formal admonition, due primarily to Ms. Trummel's willingness to re-engage and her mitigation of the injury, both to the profession and to KH by refunding KH by participating in the process. Nevertheless, the hearing panel recommended published censure. And when you look at the hearing panel's reasoning, which is really thorough in the final hearing report, it becomes very clear how they weighed the evidence, and that weight and explanation is largely our reason for asking this court to adopt that recommendation. The hearing panel examined 3 different ABA standards for imposing attorney discipline: the standard for lack of diligence, which is 4.4, the standard for failure to preserve client property, which is 4.1, and the standard for violating the duties we owe as professionals, which is standard 7.0. In each of those, they looked at all 3 levels of, well, 3 of the 4 levels, I should say, of attorney discipline. They did not discuss disbarment, but they looked at the suspension level, the reprimand, or what we call censure level, and then the admonition level. Greatly summarized, all 3 suspension standards require knowing misconduct as well as actual or potential injury to either the client or the profession. The reprimand standards required negligent conduct with the same level of injury. and the admonition standards required negligent conduct and little to no injury. Ultimately, the hearing panel concluded, based on the evidence, that Ms. Trummel knowingly violated her duties under 1.3 and 8.1, that is diligence and failure to cooperate, but then acted negligently under 1.15, which is safekeeping client property. They also looked to the injury and found that the injury to KH was fairly serious, given that he was deprived of his retainer for quite some time through this process. The hearing panel also discussed the aggravating and mitigating factors. I won't dwell on those too long, except to say that they discussed that Ms. Trummel had had a prior diversion, which was successfully completed in early 2021 for similar misconduct. They found a pattern of misconduct, both in this case and with the similar misconduct in the diversion.
The diversion had two cases.
I'm
Yeah.
sorry?
The diversion had two cases.
The diversion was extended for an additional
Two
violation.
complaints, I should say.
Yes. Yes, so the diversion had multiple clients affected and it was extended for an additional, I believe, 180 days for additional misconduct that had come to light. The hearing panel found bad faith obstruction of the disciplinary proceedings for her failure to cooperate for the long period of time, that she had had substantial experience in the practice of law, and that she had an indifference to making restitution. Ms. Trummel testified that she did not know if she could engage KH to reach out and possibly refund him during the process, and the hearing panel reasoned she could have found out that answer if she was cooperating, but she did not. However, the hearing panel ultimately also weighed very heavily her mitigating factors, her absence of a dishonest or selfish motive. They noted that her misconduct wasn't malicious. She was not doing this in that manner, and credited her personal or emotional problems, specifically her anxiety. And so ultimately, they recommended a published censure. My office would ask this court to adopt that recommendation at this time, and I'm happy to answer any questions the court might have.
The panel also said that it's seriously considered a period of suspension. I guess my takeaway from this is I don't understand why we're not helping the respondent practice law better. I mean, you would think someone who'd been in practicing law since 1993 would know, to have a trust account. That's, obviously basic. It's obviously basic that you cooperate when the disciplinary people send you a letter and have investigators going in. I think it's obvious that you return the money sometime right before the hearing. That doesn't really carry a lot of sincerity to it. And then it appears that the respondent says, well, yeah, I've been practicing since 93, but I was doing public law and I was in a government association, so I didn't know all the niceties of this. And then I become concerned about letting her loose to practice law without knowing these things. So was that part of anybody's consideration that there should be a period of some kind of probation and supervision of the practice to make sure that the basics are being covered, especially when she says, I don't know what the basics are because I was off doing this other stuff.
I appreciate very much that question. I think there are a couple different components to it. The first is, as it comes to the trust account, I believe her testimony was essentially that another attorney had set it up and she trusted it was set up correctly. One of the things, I believe the trust account records are, I don't have the exhibit number off the top of my head. I want to say something around exhibit 7, but I may be incorrect on that. What the investigation as well as the hearing sort of brought to light, and it wasn't discussed extensively at the hearing, was the account that Ms. Trummel treated as a trust account was being treated appropriately. She at one point charged something that she knew was not a client expense. She accidentally charged it to the wrong account. She immediately refunded it and fixed it. And I am about to run out of time, so may I continue?
You may proceed.
Thank you. So there is that portion of it. I think one of the things the testimony at the hearing shows is Ms. Trummel.
Let me back. That isn't a good answer. We all know that even if you're treating a checking account like a trust account, you document the flow of money coming out. You document your time that you're charging against the account, whatever it is. That wasn't done here. So I don't think we can brush this off that way. Tell me why you think the public is going to be protected by the recommendation you've made.
I think the public is going to be protected because Ms. Trummel recognizes what she did wrong in this case. And the case is based on the complaint we had. And so part of that is that, we had KH's case. I cannot speak to any other client's case and what that looks like.
The answer she's giving in response to
Right.
that complaint. That's what's causing me to wonder whether she knows how to practice law.
I believe that her ability to take responsibility, to recognize the mistakes she made in this case, and to then, because she admitted fully that she should have had the records, that she didn't. She discussed the fact that she did not have good support. She did not blame her support staff, but recognized she didn't have good support staff. And that was impacting her ability to, practice as adeptly. That's not the word I want, but that is the word that has come into my mind at that time. And I think when we think about why we impose attorney discipline, we look at addressing the misconduct, ensuring that the attorney remedies the issues, and protection of the public. She has recognized her errors. My understanding is she fixed the trust account. She's in the process of fixing the trust account. It has now been fixed so that it is properly set up. She was more than willing to do whatever she needed to do to correct the misconduct. Yes, shortly before the hearing, but nevertheless, jump back in to do that. And so my position is simply, does not appear to be a case where she needs to step away from the practice of law to reflect and correct. There was no discussion about probation. Obviously, if probation were to be on the table, there would have needed to be a probation plan submitted 14 days before the hearing. That was not at issue in this case because of how the recommendation ultimately ended up, how the case ultimately ended up coming through. And so while there is, with any case where we are not, I suppose, suspending an attorney, there is a risk of the protection of the public not being protected because we see only the one case in front of us, both my office and this court, and has to make a determination based on the facts of this one case. Do we think there is a spider web of other problems behind the scenes? And although we have only the picture of KH, that was not a conclusion that we came to. I think the hearing panel does, both in its questioning of Ms. Trummel and in the final hearing report, lay out sort of some of the concerns that were raised for them that ultimately did not lead them to recommend a more severe sanction, but nevertheless sort of alert Ms. Trummel to them. For instance, there were questionings about, have you considered when you take small retainers, the additional steps that creates? That was a question from one of the hearing panel members, talking about, understanding the impact on some of these things on low income individuals. I think that's all baked in there. And so while I cannot guarantee that, nor can we in any case, that published censure is going to ensure that there is never any harm to a future client, based on the record that is before us. And again, Ms. Trummel's willingness to do what she needed to correct her misconduct and move forward and keep doing the good work that she seems to be doing for her clients. Because again, she has one instance of prior discipline in the form of the diversion. This is not an attorney who has seen this court many times before. That is why published censure is appropriate.
Any other inquiry, colleagues? Thank you, Ms. Duncan.
Okay.
May it please the court, Luann Trummel appearing pro se. And I'll say that I am appearing pro se because I don't have great arguments to be made against the allegations made by the disciplinary administrator's office. Ms. Butler is correct that I did respond to Mr. West's initial inquiry in January 2023 regarding the complaint from Mr. Hawley. I'm sorry, KH. Apologize for that. In that response, I indicated that I could not locate the opposing party. I did continue to be able to locate the other party without success. That was not properly documented. I agree that I did not provide appropriate responses to KH, nor did I take the action for which I was retained. KH made an initial payment, which was not placed in an approved trust account. As Ms. Butler indicated, when I began the private practice of law, my account was set up with the help of my partner at the time, who was a longtime attorney, and her name appeared as a co-signer on the account. And I believe that was an appropriate account. Obviously, I've learned differently. I have set up an appropriate IOLTA account that was established and recorded more than a year ago, or approximately a year ago. After my initial response to Mr. West, I failed to respond to the local investigation by Mr. Dillon, and I did not respond to the investigation, which resulted directly from the disciplinary administrator's office. It was not until later, when I spoke with the investigator and Ms. Butler at the pre-hearing conference, that I began to try to rectify as much of this situation as possible. I can tell you at the time that all of this first occurred, I was suffering from a great deal of anxiety, which was part of the reason I didn't respond. Of course, I know the importance of communication with clients. Of course, I understand the importance of keeping a client up to date on the status of a case. At that time, I simply couldn't, which I understand is nebulous. But when you are suffering from anxiety, sometimes you just can't move. I can tell you at the time, I was providing services to low-income clients who could not afford expensive representation. However, low income also means clients who just fail to pay at all. I had little to no paid staff during that time, and I couldn't keep up. As Ms. Butler indicated, I am not blaming any staff I had. I was in charge. It's my responsibility. All of this was my responsibility. I was overwhelmed, but I did not reach out for help. In order to address my previous failures, I've now changed my practice to a mostly contract-based practice where I am able to afford competent and vigilant support staff, including a paralegal who makes it her mission in life to keep me on track and take care of clients and help me take care of clients. Perhaps none of that is necessarily relevant today. I took responsibility before the panel, and I take full responsibility now. The panel recommended public censure rather than suspension of my license. It is my hope today that you follow that recommendation as Ms. Butler indicated, I took no exception to the hearing panel's final report. And I ask that you follow that recommendation, and I stand free for questions.
Any questions, colleagues? Thank you, Ms. Trummel.
Thank you.
Ms. Butler, you reserve 3 minutes.
Unless this court would have any questions for me, I would waive my rebuttal time.
Any questions? Thank you, Ms. Butler.
Thank you.
That concludes this morning's dockets, and court will be in recess until 9 a.m. tomorrow morning. Thank you.